in the workplace. The state legislature passed a bill last month barring employers from firing or refusing to hire people who use cannabis in their off hours. The governor has until the end of the month to sign it. Joining us live to talk about the proposal is employment attorney Angela Reddock-Wright. Thank you so much for being with us this morning, Angela.
Good morning. Thank you for having me.
First off, can you just tell us a little about this bill and what's in it?
So, Rachel, this law is a part of a body of laws we're starting to see that protect employees in the workplace with respect to cannabis use, and other cannabis laws that work with cannabis owners, store and retail owners, to set the laws and the regulations for their industry. As you indicated, this particular law prohibits employers from discriminating, whether it be in hiring or firing or in any other condition of employment, from discriminating against employees who use marijuana for recreational purposes or for medical marijuana purposes or otherwise legal purposes now in the state of California.
Because right now, marijuana is legal in the state of California. So you all are arguing, why are some of these employers then drug testing employees and candidates?
Yes. So, as you know, traditionally employers drug test applicants for employment, and that's still allowed. This law does not prevent employers from drug testing applicants for employment or employees who work in a position, a safety position, for example, such as in the building and trades industry or law enforcement, a position that requires employees to have their full senses about them, so to speak. So that's still allowed. But what's not allowed, and employers can still drug test, but they can't make decisions. For example, if they find traces of THC in an employee's system, they can't automatically fire or terminate or suspend or take any action simply because THC exists in the system.
Gotcha. And so, Angela, some business groups have said this would make it more difficult to punish employees who may be high on the job. Is there any truth to that?
Well, the way the law is written, it says that, as I stated, employers can still drug test, and if employees find active antibodies, for example, of THC, which suggests that there's recent impairment, along with other testing to show whether the impairment impacts the employee's job, that's still allowed. And employers can take action if they have reason to believe or suspicion to believe that an employee is actually impaired from doing their job, and that it puts the public, for example, at danger. But what it does limit is just, someone had recreational use possibly in the last few weeks, and there's no relationship to their job or any potential impairment to their job. It prevents the employer from taking action such as termination or suspension in those situations.
Got it. And what industries are impacted by this?
Well, the industries that are exempt are the building and construction trades industry, because presumably those individuals are on top of high buildings and building things and need to be at all times at full capacity, mental and physical capacity. And it also exempts employees who work in jobs that require federal background investigations. So what that means is that all other industries are subject to this law, and whether it be in, healthcare, the grocery industry, office jobs, all of these industries now have to comply with this particular law.
And so marijuana use, we know, still against federal law. Does it matter in this instance? Does the state law trump then the federal law?
So what's interesting is, although it's still illegal based on federal law, essentially the federal government has taken a hands-off approach when it comes to states regulating the use of marijuana in the workplace or just generally. So while the federal government could, based on it being illegal, come in and shut down marijuana stores and challenge the California law and other states who have made recreational use of marijuana legal, conceivably the federal government could step in and take action, but they haven't. They're essentially allowing the states to regulate.
And why now? What inspired this bill?
Well, recreational use of marijuana, medical use of marijuana passed several years ago, and this is one of many bills that the California enforced and passed in an effort to set standards for this industry.
Okay, now I want to move next to the pay transparency bill. Can you talk a little bit about that? Because we know that's also on the governor's desk right now.
Right. So this is a part of a series of state laws as well, designed to kind of even the pay gap among women and among minorities compared to others. And so the most recent bill is called Senate Bill 1162, will require employers to publicize in their job descriptions, even if they place the job descriptions with third-party agencies like LinkedIn or Indeed, to publicize the pay scale for a particular job. So this is a part of a wave of laws that we've seen designed to even the playing field when it comes to pay in the workplace.
And that seems so important because right now, if you're a job seeker, you look on websites, some publish, some don't, and you never really know, you get a good sense of what that job should pay. So the ones who are publishing right now, that's voluntary then, it sounds like.
Yes, and what this law does, if an employer is in California, they have an operation in California, they have 15 or more employees, they are subject to this new law. And then employers that have 100 or more employees are also required to publish the data with the Department of Fair Employment and Housing on an annual basis, and then that data becomes public to the entire public. Right. And so it's all designed to let applicants and job seekers know kind of what to expect in terms of pay, and also for current employees to know if they're being fairly paid compared to their colleagues and their peers.
So say this bill doesn't pass, I should say, what laws are already on the books that workers and job seekers can use to make sure they are receiving fair pay?
Well, at the core, we have what's called the California Fair Employment and Housing Act, and that is the act that prevents discrimination and harassment by employers for engaging in any conduct that would be discriminatory towards individuals based on a protected category such as race or gender. That law also was expanded through the California Fair Pay Act to ensure that both men and women and minorities are paid equally for substantially similar work. So those are laws that are on the books. And then an additional law, as I mentioned, that requires publication of data with the California, now it's called the Civil Rights Enforcement Agency, formerly called the California Department of Fair Employment and Housing, to publish pay data on an annual basis, all designed to create transparency. And when that's not done, there is the possibility of fines.
And finally, Angela, how confident are you that this marijuana bill and this pay transparency bill that are on the governor's desk right now, how confident are you that they will pass into law?
You know, given the trajectory of California when it comes to protections for employees in the workplace, I'm confident that these bills will pass and that the governor will sign them.
Angela Reddock-Wright, thank you so much for joining us. We appreciate you.
Thank you.
And we talked to experts several times